Hello again, everybody, and welcome to Quigley on Divorce, a behind-the-scenes look. I'm your host, James Quigley, and today I am honored and pleased to have with us a very special guest, Alex Jacobson. Alex, welcome.
Thank you for having me.
So today's conversation is going to be about mediation, and who better to talk about mediation than a professional mediator in Alex. In all candor, I have a disclaimer to make that Alex and I first met as combatants, and Alex has been a partner in a competitor firm and has moved into the world of mediation now. But really, your roots started as a day-to-day, day-in, day-out divorce lawyer. True?
That's right. For the past 12 years, I was at one of the other larger divorce firms in the city, and that's where I grew up as a lawyer. Started there as a summer associate and practiced for 12 years. And after the last 2 or so years, I started thinking about changing the direction of my practice and realized that even the most high conflict cases were able to reach a resolution outside of the courtroom. And those results were often better than when agreements were reached on the eve of trial, or certainly when judgments were imposed upon parties by the court.
Yeah. And I think in today's climate, mediation is something, first of all, in the outside world, which again, for the viewers and listeners, many more people, are even coming to me as a practitioner saying, what about mediation? It's much more prevalent now, I think, even than when you started, or certainly when I started.
Certainly.
And so I think it's taking roots, and I think it's creating really an interesting space for people to resolve their disputes in an alternative way.
Absolutely. I mean, I think that mediation used to be viewed as something that was only for the ultra wealthy people. And now there are mediators that cater to the average case. And quite frankly, any case, whether you have simply a house and a pension, all the way up to complex financial cases, are appropriate for mediation if two people voluntarily want to participate in a process that is non-adversarial, confidential, and both efficient in terms of finances and in terms of emotions.
So tell me this, you said non-adversarial. Is mediation really always non-adversarial?
Okay, good point. Not necessarily, but it's my role as a mediator to help keep the adversarial nature of the process down. And I do that by in several ways. First, I'll often have parties starting together in a room, but then I can put them in separate rooms and shuttle in between them and help navigate the conversation in a way that keeps the temperature down.
So from just kind of a history of mediation, it's really interesting. So I started in 92, and back then, literally the only mediation services available were provided through Cook County. And it was really limited to those circumstances whereby there was a custody dispute. And again, that nomenclature's changed, but there was a custody dispute, and sometimes the courts, before they would entertain any litigation regarding children, they would order the parties to go to mediation, and it would take months. And it was relatively inexpensive because it was through the county, but there really wasn't financial mediation. There's certainly the private mediation really wasn't what it was, or what it has become back then. And so today, though, mediation has expanded far beyond just child-related issues. But talk to the viewers and listeners first about mediation as a way of resolving child-related issues and keeping those issues out of court.
Certainly. So it's mandatory for all child-related cases for the court to send those cases to mediation prior to anyone getting a trial or hearing date. So you're not really going to have a choice if you're litigating parenting matters. You're going to have to mediate the issues.
And tell me why. Why do you think the legislature, at least here in Illinois, has made that mandatory as it relates to child-related issues?
I think that parents know best what, in terms of reaching an agreement that is appropriate and narrowly tailored to the needs of their family. And also, if you are able to reach an agreement, you're more likely to follow it than if an order is imposed upon you. And so I think that the idea is that they want these agreements to be followed, and parents have to continue co-parenting after they are divorced. And so in an effort to try to get them to a place where they can get along for the benefit of their children, it's a way to resolve the issues, again, in a non-adversarial or less adversarial process.
Which to me is always seems very commonsensical. I'm a parent, you're a parent. And when you were a litigator, certainly we've been in these cases where you've got parents that are literally turning over the issues of decision making and when they get to see their children to a judge who, they're well intended, but they've got many, many cases. They don't really know the dynamics. And so it's always struck me as odd that people wouldn't engage more in the mediation process as it relates to the kids. And now it's mandatory, which I think is really a great first step. But to your point, I think the interesting thing is when you go through mediation, the people are invested in that and they understand they've got some control over the outcome. And so is your job in a mediation, whether it's child related or something else, is it to kind of steer towards an outcome, or what is it that you're trying to accomplish as a mediator with people in that kind of setting?
As a mediator, I'm trying to help them get to yes. So if they have a child with special needs, I'm helping them navigate the conversation to make sure that they have contemplated as many possible contingencies in that agreement so that they can move forward after the divorce in a way that is most productive and most helpful for their child. If they have a child who is a superstar athlete, that child has different needs in terms of practices, and that will impact a parenting schedule. The parents are the ones who are going to best know how that schedule should be implemented, not a court who's going to have, less than 5 to 15 minutes to spend with those parents to understand what that schedule needs to be.
Yeah. So you mentioned, just kind of picking up on just that little snippet of 5 to 15 minutes. If someone's watching or listening to this and they're trying to understand what mediation process really looks like, it's not every 30 days my lawyer goes to court. What is it? Can we mediate a resolution in an hour? Is it 10 sessions over 10 weeks? Give some context to the scope of what mediation looks like as far as a process.
Certainly, and like a good lawyer, I'll hedge my answer.
Don't commit to anything.
So it obviously depends on what issues are at play. But I have had instances where start to finish, a couple has reached an agreement on all parenting issues in a matter of a few hours. There are parents who take 45 minutes to say their first and last name, and need to do so in separate rooms. And, and it takes a while for them to sort of ease into the process. So it can take any number of sessions, but, in a courtroom, you may be set for a pretrial conference or a hearing. Your attorneys have prepared, you've waited, 60, 90 days for this particular date. Your case gets called, the judge may have 16 cases lined up behind you, and you may not get but more than 5-10 minutes of the judge's time.
Or better yet, the judge isn't there that day.
And then
you're back a month later.
Certainly. Yeah. And when you are set for mediation, barring unforeseen circumstances, you are set for that day for whatever period of time you and the parties and the mediator determine is appropriate, and for any number of sessions that is necessary to reach an agreement. So it's a more controlled environment.
Interesting. Going back to when you were talking about, your job as a mediator is to, I think you said, is to get them to yes, meaning they've reached an agreement. How do you feel, if at all, your actual training and experience as a divorce litigator helps you to try to bring people to that yes?
So, I think that I have a unique perspective given my practice to be able to provide an evaluative perspective and, challenge somebody's strengths and weaknesses of their position on a particular issue so that they recognize, well, look, I may want to compromise on this particular issue because if we don't reach an agreement here, I do have to go down the street to the courthouse and, I've been now given some perspective on what a judge may or may not do if I take that position all the way to a hearing or a trial.
So that's something you can bring to a mediation as a mediator. You can you're not telling someone they have to do this or have to do that, but you can share with them your perspectives of, if you don't resolve something here, this is kind of what you're looking at.
Certainly.
Yeah.
Certainly.
And that can be impactful. And that's an understanding the cost of doing that, the acrimony of doing that, all of
the stress.
Which is,
absolutely. I mean, I think there are former judges that are practicing mediation, and certainly they have
not as well as you.
Absolutely not. No, but they have obviously a very unique perspective, and can provide, that type of evaluative perspective to the parties that are before them. There are also a lot of mental health professionals that are practicing as mediators. And while quite good at a lot of the parenting issues, they lack the experience in a courtroom to provide that evaluative perspective, which I think can be helpful to move parties to get to yes.
Right. And I mean, 100% agree. And that's why, so supportive of your endeavors, just because I know what you know from a litigation standpoint. I know what you can bring to parties who are in conflict, and helping them to try to avoid the nastiness, the cost, and all this stuff that, you've lived for a long time as a litigator, and I'm still living.
Mm-hmm.
So I think that's really valuable. Tell me about financial mediation, because it's been around, but it's really become more of a newer phenomenon, where actually the courts here in Illinois can order litigants to mediate financial issues. True?
Absolutely. So it's permissive for a judge to send any issue to mediation. I mean, it could be a discrete discovery issue. It could be any financial issue. It could be a temporary support issue. And in mediation, whereas parenting issues, I think that parents often can participate in that process without attorneys involved. Financial issues often call for attorneys to be involved, especially in instances where one or both parties may or may not be particularly familiar with their finances. Notwithstanding the fact that the attorneys are involved, it's still a more efficient process, because for all of the reasons that the parenting mediation is. I mean, it's set times for a set amount of time, and that you either are or are not going to get an agreement at the end of that session.
Right. I've always went for your point about the attorneys being there. That's something with clients I've had. They feel very, very reassured if we're going into a financial mediation that it will be attorney assisted, meaning we or someone on our team will be there with our clients, because to your point, many individuals in a marriage or a relationship, there isn't always an equal sort of balance of knowledge in terms of the finances and who's paying the bills and what investment. So often people will feel like they are at an unequal kind of playing field. And so I think that's something too, where one thing we always focus on is, even in a mediation process, a big part of that, I would assume, for financial mediation is transparency. There has to be disclosure. We have to know what the balance sheet is, what the accounts are, the liabilities, the assets, the income, and so forth. No?
Right. And so, prior to the financial mediations, the parties exchange the financial information, review it. If there's any additional information needed beyond that, in mediation, the production of that information is voluntary, meaning both parties are going to participate in the production of that information, because they want everybody to come to the table with the information necessary to move the ball forward. And to your point about, one party, may not have the knowledge of the finances, I stress that there's no shame in that. There's a division of labor that exists when two people are, in the same house, and one person may or may not be familiar with, what accounts exist, what the budget is, and what certain expenses are. And that's okay. And that's why having attorneys present during the financial mediation can be extremely helpful.
Yeah. And I think even expressing that to someone coming into a process with you, it's probably almost a relief, because I think, and I've had clients where they're very apprehensive, and, I don't know where stuff is, and he's hidden this or she's hidden that, and so just coming in, I think being able to understand that that's okay, and we'll work through that. And that's actually part of the mediation process.
Right. Absolutely.
Yeah. Interesting. So I got to ask you this because from our experiences, I'm built more as a litigator.
Mm-hmm.
And there are different styles of mediation. And candidly, I don't participate in a lot because I'm not wired that way. And I see a whiteboard and my head starts to spin and I'm looking at the snacks on the table and I'm So is there, you're obviously trained, right? This is
Right.
something. Tell me a little bit about the training you've received to be a mediator. And then how would you describe your style if that can be articulated?
Certainly. So there's a 40-hour training for mediators. Northwestern provides it. There are other, Cook County provides it. There are other services that provide the 40-hour training. But I think my best training came from being in the courtroom,
Sure.
Came from representing men and women on both sides of almost every single issue you could possibly imagine in a divorce.
Yeah.
And so that's where my best training came from. My best training came from being in the courtroom, listening to the judges, listening to the attorneys, and hearing all of these issues. And the way that I use that in my style is that I do provide that evaluative perspective. And I think that there are other styles that are a little bit more kumbaya. That's not my particular style. I want to get right to the point. I want to, move the parties to a point where there either will or will not be an agreement, but I'm not going to waste anybody's time.
Yeah. And I think it's a great point. I think that's awesome about your approach because I'm sort of wired. Let's take all this and let's funnel it down to but again, that's not to say that there are other mediation services or mediators that, and we joke about the kumbaya, but sometimes
it's fitting for some people.
Right. In some cases, that type of process. And so mediation isn't a one size fits all. Fair?
Absolutely not. Absolutely not. I mean, as I mentioned, there are mental health professionals that are doing this. There are judges that are doing this. And just by virtue of the background that you bring to the table as a mediator, that will inform your style.
Yeah. I think it's really interesting just too, when you talk about your experience and your background, you mentioned pretrial conferences. So for all these years, and you and I have sat against each other in these pretrial conferences where effectively it's almost akin to a mediation, except for the judge is trying to help the litigants through their attorneys get to yes. But at the end of the day, if they don't, then the judge has to make a decision. But I think sitting through that process in all the different judges we've appeared before, the judges have their own styles.
Absolutely.
And so I'm sure in many respects, all those experiences working with different judges and their demeanor and their temperament and their styles has in some form or another shaped how you approach your job as a mediator.
Absolutely. And there are people think that certain judges have certain slants on particular issues and mediators often and I, as a mediator, sort of take those different perspectives, understand that on any given day, a particular judge could rule in a particular way, help the parties understand that there is no certainty when they go down the street to the courthouse.
Yeah.
They retain the control if they are able to reach an agreement.
Yeah. Listen, I anecdotally almost blew my stack yesterday because I got a written ruling from a judge that I believe is so contrary to what should have happened. I can't even really make sense of it to my client. The fact of the matter is, we didn't really have a choice in that situation because we weren't, from the other side, afforded that opportunity to really negotiate a resolution. And so we put that into the hands of a judge and got an extremely unpredictable result. And so now we're talking about appeals, and all of this stuff is costing my client and the other client a lot of money. So losing that control, I think when you go into litigation, there's a time and a place for that. But I think if you can work with someone like Alex and work in a mediation process, I think that should always really be a starting point.
I couldn't agree more. I mean, there was never a more frightening day when I would tell my client, these are the facts that we are about to go argue that apply to this law, and I am almost certain that this is going to be the result. And when that result didn't come to pass, it's a terrible feeling as an attorney. Your client is dissatisfied.
Yep.
And as you said, there are certain instances where you're not afforded the opportunity to negotiate. And so you have no choice but to just put it on and have the hearing or the trial. But if you are able to reach an agreement, even though not every point of the agreement will be to your client's liking, if it can be a sufficient compromise to get everybody past the issue, I'm very much in favor.
Yeah. And I think to me, that's when you sum up mediation from my perspective, what I see and why I encourage it for my clients is because, number one, like you said, they have some control of the outcome. But number two, to get to yes, there's going to have to be compromise on both sides. But at least that way you can measure those things you're willing to concede, what those things you really don't want to lose. When you go to trial, the things you really don't want to lose, you could lose them.
You never know.
You never know. So interesting. Let me shift from what we've been talking about into mediation as it's the economics of it. Okay. So as litigators, and again, we go back to our experiences, even, having cases against each other where our clients have spent a lot of money having us fight for them and advocate for them, which we do. And you've done very aggressively and very well. But there's a huge price tag that is attached to that. How does mediation work in terms of cost? Working with someone like you, is it typical where there's a retainer? Are you hourly, but can we set parameters? How does it work?
So it's somewhat flexible, and different mediators have different strategies in terms of cost. But my typical arrangement is a retainer with I think a very reasonable hourly rate. I think that the former judges are able to command a much higher hourly rate because the types of cases that are going to them warrant that type of rate. But then there are particular issues. So for example, if when a case begins, there are a slew of immediate temporary issues that must be addressed. A temporary parenting schedule, a temporary support arrangement. I would be willing to do, a few sessions at the beginning of a case to reach a resolution on those temporary issues for a flat fee, knowing that once discovery is done and once the case progresses, the parties are going to come back to me to address a global settlement for their entire case. So there are different arrangements in terms of the economics, but by and large, it is a far more cost-efficient process than litigation because you have set the time that you're going to commit to the process, the professionals that are going to be involved in the process. You've streamlined the discovery to only what is needed in that case. I mean, often, there are discovery requests that are standardized when you are litigating that may have absolutely no relevance to a particular case. Yep. But you still have to complete them. Yep. In mediation, you can narrowly tailor everything to only what is needed to resolve that case.
Interesting. So one more thing I kind of want to get into is it's pretty common, and you'll know this from your days, in the trenches as a divorce lawyer, where in certain relationships, there's abuse, physical abuse, verbal abuse, mental health issues, addiction problems. Are you still able to mediate when those issues exist in a marital relationship that's now going through divorce? And if so, how do you manage those issues?
So I think the common answer to that question is that those cases would not be appropriate for mediation. I tend to not agree with that. I actually think that if those individuals are represented by counsel and have somebody advocating their interests and who can work with their mental health professionals, their clients in mental health professionals, and have those outside resources so that everybody who's coming to the table reaching an agreement can do so knowing that everybody is understanding the terms of the agreement and willing to abide by it. I'm more comfortable mediating those types of cases. I would be concerned mediating those types of cases if those individuals are not represented by counsel.
Interesting. And would you have to get releases from the litigants that are meeting with you if you're getting mental health professionals, for example, to kind of
if the mental
weigh
health
in?
professional is speaking with me, then yes.
Okay.
But if the mental health professional is working with their own attorney,
Okay.
that's something that they would do on the side, separate and apart from me. I just would want to know that everybody who's signing a document understands what they're signing.
That makes sense. That makes sense.
And in the context of a domestic violence situation, that is an instance where I'm not saying it's not possible to mediate. You would do so with the parties in separate rooms.
Yeah. Yeah. So I want to wrap up on the last concept of mediation being, number one, is it confidential? Can it be used? Let's say mediation, best efforts, you do a great job. People just can't agree upon anything. We're going back to court. Quigley's litigating. Can someone come in and say, hey, I want Alex to testify that my husband was a real jerk? How does it work?
The answer is categorically no.
Okay.
My agreement that I have with the people who are going to mediate with me is that I will not be called as a witness, and that the communications in the mediation are confidential. Obviously, there are communications that occur in mediation that are also taking place outside of the mediation context. So, for example, a financial affidavit that's prepared for mediation, that same financial affidavit may also be used in the litigation because it's the same information.
Sure.
But I am not, I remain separate and apart from the litigation process.
Yeah. And I think that's a really important point to close on, because I think it would make sense that to be able to get people to yes, they've got to feel comfortable that they can speak their mind. Maybe I do get upset in the moment. Maybe I share something because I want to be candid, but I might not use that in a litigation sense. And you have to be free to really get it all out on the table. That's how we're going to get that resolution.
Certainly. I mean, it promotes, free communication on all of the issues so that, people are getting everything out on the table to move the ball forward. But if they're feeling inhibited because they're afraid that anything that they say will be used against them, if the mediation is not successful, it's not going to be a productive process.
Yeah. Well, again, I am so honored and privileged for Alex Jacobson to have joined us today. Alex, because you are an amazing mediator, and anybody watching or listening, I want them to be able to know how to find you.
Yes.
Do you have a website, phone number? Tell people how they can reach you.
Yes, I can be reached at jacobsonmediationgroup.com, and my phone number is 312-877-5092.
And Jacobson is spelled how?
Jacobson.
Awesome. Thank you so much, and I hope you enjoyed. Take care.
Thank you.
Awesome.